Hello everyone and welcome to today's MONDAC webinar in association with Akin and an expert panel who will be exploring US forced labour and trade remedy enforcement, providing key strategies for adapting to the realities of the new regulations. My name is Jenna Joyner and I'm joined by a brilliant panel to take us through today's discussion. Matthew Nicely is a partner in the firm's international trade practice. He focuses mostly on trade remedies, customs, and other trade policies affecting the importation of goods. He also advises clients on opportunities and risks presented by international obligations under bilateral, regional, and multilateral trade and investment agreements, including WTO dispute resolution and counselling. Brooke Davies counsels clients in a broad range of international trade matters, including WTO agreements and disputes, international trade law, trade remedies and sanctions, and export controls. Brooke also represents clients on trade matters related to Section 301 tariffs. Brooke has experience conducting internal investigations into existing sanctions compliance programs. Brooke is also active in pro bono representations. Before I hand over to the panel to begin today's webinar, a housekeeping item for you. If you can submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page, the panel will then endeavour to answer as many questions as possible during the Q&A session, but please do reach out to them after the webinar for additional information. It is now my pleasure to hand you over to Matthew and Brooke to begin. Thank you.
Thanks, Jenna. Hi, everybody. Matt Nicely here. The title of our presentation today begins with forced labor, but we're going to switch the order and start with an overview of the trade remedy, more generally the other kinds of restrictions that companies face bringing product into the United States. And so we'll run through a little bit of a background on AD, CVD, anti-dumping and countervailing duties, and go through some of those details to make sure that people recognize the various risks that they face there, and then talk about some of the other provisions that have been used in recent history or currently still being used, started by the Trump administration, but continued by the Biden administration. And then Brooke will take over and talk through all these latest issues that are facing many companies with regard to forced labor. So why don't we jump to slide, Aaron, why don't we just jump to slide 5 just to get us going here. Anti-dumping and countervailing duties are the most common types of trade remedies that we have in the United States. They're the most common across the world. They're governed by WTO agreements that permit imposition of additional duties when an unfair type of trade activity is happening, specifically dumping, which is a form of price discrimination between markets, or subsidization, which is by the foreign government, which is being countervailed by the countervailing duty law. These types of activities are only remediable if they are actually injurious. So you have not only the petitioners who bring these cases don't have to only prove that dumping is happening or that subsidization is happening, but they have to prove that the imports are actually from the targeted countries are actually causing injury as well. The remedy for these are usually duties, but there are also suspension agreements that can be entered into or undertakings. But those are, in the United States, those are less common than they might be in other countries. But there are several products that we have subjected to these what are called suspension agreements here in the United States. Let's jump to the next slide. In the United States, you have two different agencies that handle anti-dumping and countervailing duties. One is the Department of Commerce that handles the question of whether or not there is in fact dumping or whether there is in fact subsidization that can be countervailed. And then the second agency is the International Trade Commission, which handles the question of whether or not those imports are causing injury or whether they're a threat to the injury, threat of injury to the domestic industry. It's common these days for both kinds of cases to be brought at once, particularly in cases against China, which is the largest target here in the United States, of course. And in fact, with that, let me just go to the next slide, and you can see the focus of where our current proceedings, current investigations, as well as orders. Orders are what happen if both agencies go affirmative and you actually have an anti-dumping or countervailing order in place, or you have a suspension agreement. As you can see, there are many pending investigations right now. 2023 was actually a pretty big year. As some of you may know, there's a very controversial case that's going on right now on aluminum extrusions, which is causing a lot of consternation because of how broadly the scope is written in that case. But generally, these cases are thriving right now, I would say, with multiple petitions having been filed and multiple investigations pending right now. But the orders, for those of us who practice in this area, the hundreds of orders that are in place continue to create, work for not only for people who do what we do, but for the companies who are subjected to them to have to monitor them and make sure that if you're a seller, if you're an exporter to the United States, that you're not putting yourself and your importers of record in a difficult space by having to potentially pay retrospective duties, which is an important hallmark of our U.S. law, which I'll get to in a moment. But those orders can be in place for many years, and so that monitoring effort to make sure that you're managing the risk associated with these anti-dumping and countervailing duties orders is really important. Suspension agreements are much less, as you can see here on this slide. They're few and far between, so they're not as common, and we don't need to spend a lot of time on them today. Let's move on to the next slide. The real point I want to get across here, and I don't want to spend a lot of time on this today, but I do want to make sure that the audience is understanding the risks that I just alluded to a moment ago associated with the way in which our law works in the United States. We have what's called a retrospective system, which means that the duties that are actually ultimately paid are not known at the time of entry of the product into the United States. When the product hits the United States, the importer pays what's called a cash deposit at that time, and that's a cash deposit that is determined at the time of the investigation or successive administrative reviews, but it's not until those administrative reviews that happen on an annual basis that the Commerce Department looks back and says, okay, let's look at this period of time in the past, and the importer may have paid a 10% cash deposit because that was the amount, that was the percentage calculated during, say, the investigation. But in fact, Commerce determines that the actual amount of dumping that happened during that period of time was 20 or 30 or 40%, in which case the importer of record owes the difference, owes the additional amount. That's called an assessment rate, because they assess the duties later on after the entry has already come in. So we consumers in the United States might have already literally consumed the product, but the final duty liability is not known until later. This is not an insurmountable issue under our law, but it is one that creates a lot of risk and difficulty for the companies involved, either the exporters or the importers. And with many industries, sometimes even the downstream companies. The downstream companies don't have liability vis-a-vis the customs service or customs and border protection, but they may have contractual obligations to the importer of record, depending upon how wise they have been about how they handle those contracts. So this retrospective system, really important for folks to recognize how the United States does it. And this is not new, but it is an area that becomes that arguably is becoming more and more difficult for companies to address because of some of the other issues that have been happening in recent years. Let's go to the next slide. Other kinds of proceedings that happen under our law is a sunset review. This is a provision that entered in once the members of the WTO agreed to the new anti-dumping and countervailing duty agreements, where every country is supposed to do this. Every 5 years, they're supposed to reconsider whether or not the orders are really necessary, should they stay in place or not. The Commerce Department determines whether or not if the order were removed, would it cause injury? If the order was removed, would dumping continue or would subsidization continue? The Commerce Department's standard is very, very difficult to overcome, and frankly is frankly impossible to overcome unless, as I say here in the slide, unless you got 0% rates, dumping rates or subsidy rates, and over the course of the 5 years that they look at during the sunset review. So very difficult to win. The ITC, the injury analysis, the ITC looks at whether or not injury is likely to continue or recur in the absence of an order, and that's difficult but not impossible to overcome. And so that's one way in which these orders will go away. But there are examples of orders that have been placed for decades. So it's possible that you're working in a particular industry where you're facing these duties for a long period of time. Change circumstance reviews, that's just another proceeding. We don't need to really talk about that today, but circumvention and scope proceedings have become a bigger deal, particularly circumvention. And again, just another example of where retroactive liability can kick in. We'll, as a result of that, because it's so important, and is one way in which this law can catch people by surprise, we'll spend a little bit of time on that today. Okay, next slide. This slide just shares with you, and we'll be sharing these slides after we're done today for the participants. So I won't dwell on the math, but it's fairly straightforward, although this slide maybe oversimplifies it, because the calculations are done on a line item by line item basis. The way in which the Commerce Department conducts their investigations and their reviews is to look at very, very detailed sales lists on a item by item, transaction by transaction basis, item by item, product by product. So this very simplified calculation that you see here is happening for multiple transactions, and at the end of the day, at the end of the analysis, they take a weighted average. But basically, what you're looking at, and this is the price discrimination calculation I talked about earlier, where U.S. price is under, the price for the U.S. sale is lower than what's called normal value, which is normally the home market, but can be some other substitute. And if that price in the U.S. market is lower than what's called normal value, then you're dumping. This is also, and the fact that you have multiple transactions going on, this is where some of you may have heard about this whole zeroing controversy over the zeroing practice that the United States and many other countries used to use, that the WTO had found to be WTO inconsistent. And that's frankly one of the reasons why the WTO dispute settlement system isn't working very well these days. But that zeroing practice is where is the notion of increasing to zero negative dumping margins for those transactions, those comparisons that draw not just a zero dumping margin, but a negative dumping margin. And the big controversy there is, should you treat that as zero, or should the companies be getting the benefit of that negative dumping when the whole weighted average is calculated? But anyway, that's enough on the math. Let's move on to the next slide. This is really important for companies that are seeking to maybe adjust their supply chains in light of all the various challenges that face companies that are selling to the United States. China is a a country that is a big target, and they are considered a non-market economy. And so the calculation of the dumping margin for China is rather unfavorable, because companies can't know whether they're dumping or not until the actual proceeding happens, because they don't know what the Commerce Department will ultimately use to calculate normal value, because it's not their own transaction, say in their home market or in a comparison market. It's instead a sort of a Frankenstein looking type of calculation that uses their factors of production, and then you go to another country and get surrogate values. And so companies can't know whether they're dumping or not. And as a result, in China cases, it's not uncommon for dumping margins to vary from one review to the next quite a lot. When companies are thinking about potentially adjusting their supply chain away from China, because of this and other concerns, including forced labor concerns that Brooke will talk about in a bit, and maybe also because of Section 301 duties, et cetera, then they have to consider where are they going to go, and are they going to go to another country where there are other types of where they also face similar challenges. Well, Vietnam is oftentimes a place where Chinese companies will build facilities. They face the same, companies face the same kinds of difficulties with the non-market economy methodology in Vietnam. Now, Vietnam is currently challenging that methodology, hoping that the United States will treat Vietnam differently from China, but we don't know how that will go yet. So, but this methodology that's used for non-market economies is something for folks to be aware of and recognize that there's additional risk associated with doing business with non-market economies. Let's go on to the next slide. Subsidies, so countervailing duty cases address subsidization, but they don't address all kinds of subsidization. So the quick and dirty explanation from a, sort of taking off the legal elements is there a financial contribution that from a government that confers a benefit, and is that benefit, is it specific? So for instance, infrastructure type, that we all benefit from is a general subsidy. That's not something that we try to countervail. On the other hand, the fact is the United States has defined specificity fairly broadly, so it's something to be careful of. Normally, this calculation is not as complicated as the dumping calculation. They're looking at the extent of the subsidization, and they're dividing by a sales value. If it's a domestic subsidy, they take the total sales value. They take the total amount of the subsidy and divide by the total sales value. Generally, subsidy margins in the United States at the Commerce Department tend to be much lower than dumping margins, but not always. So it's an area that makes sense to watch. But there are many fewer countervailing duty cases, countervailing duty orders than there are dumping orders. So dumping tends to be the focal point for many people, and that's the one where there can be much more variability from one year to the next as well. Okay, let's go to the next slide. Standing, this is just something to be aware of that is required for new investigations. It's not required for other types of proceedings, only investigations where for an industry to bring a new case, they do have to meet this standard for what's called a standing requirement or representativeness requirement to bring a new case. The petitioners have to represent at least 25% of domestic production, and they have to be, they and their supporters have to be 50% of those who of the production of those who express an opinion. So standard that isn't always easy to meet. Industries are allowed to talk with each other. Companies are allowed to talk with each other and bring cases. Sometimes people think, wait a second, isn't that a violation of the antitrust laws? But there is an exception that allows companies to get together, petitioning companies to get together and talk with one another and bring these cases that are by definition anti-competitive. Okay, next slide. All right, so administrative reviews. Let's go to the next one. This is I've essentially talked about this already. This is the point that I just want to make sure everybody's aware of, that this is the really unique risk. It's the unique hallmark of U.S. anti-dumping and countervailing duty law, and it is a unique risk associated with that law that companies need to be aware of and prepared for. We don't need to dwell on this. It's in the slides that you'll have, but you just once again need to be prepared that this is an area where importers of record and their customers, if they're not being very careful with their contracts, need to be watching. Let's go to the next slide. Okay, next one. Circumvention cases are cases where the most common these days is addresses what I'll call what the companies complaining about this activity will call nation jumping, if you will. So for instance, a product is produced in China. The companies in China are faced with a dumping order, and they decide, okay, we're going to start producing in another country or countries, and we're going to ship some of our product, some of the inputs for that production from China to the other country. Then the question becomes, under one of the provisions here that we have listed on this slide, is whether or not that production that happens in the new country is only minor and insignificant. And so what has happened in several cases over the last several years is that petitioning industries or individual companies, because they don't have to meet the standing requirement, can file an allegation that circumvention has happened, that the processing that's happening in the new country is only minor and insignificant, and therefore those shipments from those countries should be brought within and considered essentially, in my example that I use, Chinese product of China. This has happened in some very, very big cases, the steel cases, where the claim was made that turning a hot rolled steel product into cold rolled or corrosion resistant steel is in fact circumventing an order on hot rolled steel from China, or on one of those other products. It has varied amongst the products, the steel products. Solar is another example, a case that we were very involved in. Another example where solar cells that were traditionally being sold and produced and sold from China were then being produced and sold from Vietnam, Thailand, Malaysia, and Cambodia, and it was determined that some of those products were in fact circumventing when they were made from products that came from China. So and a lot of money is at stake. Again, the retroactivity issue is significant here because you can go back and go backwards and require companies to pay duties for back to the date of initiation of the circumvention inquiry. So and the amount of duties at stake can be very significant, because oftentimes if they're China cases, they can end up sticking these imports with what's called the countrywide rate in China cases, which can be sometimes in the hundreds of percentage points. Let's go to the next slide. This is just showing the trends and what's happened. I'm only taking you through 2022 here. 2023 was actually a big year for investigations, but the reason for this slide is to show you that what seems to have occurred, at least in 2022 in particular, was that instead of bringing new cases against new countries, the approach that has been adopted by at least some industries in the United States is to file circumvention cases instead. And again, that standard for getting the Commerce Department to bring those cases is lower, and it's been particularly given since the steel cases that I mentioned before over the last few years, it's been demonstrated that the Commerce Department is more sympathetic to these, and that's why you're seeing more and more of them. Okay, let's go to the next slide. to save on some time here, I think I'm going to jump through this. This is sort of, I've kind of addressed this already. Let's go to the next slide. This is again a topic that for those of you who may be considering, you know, adjusting supply chains and wondering whether or not you could get caught up with one of these circumvention cases if you're dealing with a product that is already subject to anti-dumping or countervailing duty orders against China, for instance. These details are really important and important to watch, important to understand, important to hire counsel to help with, because the way the cases end up being, how circumvention ends up being defined by the Commerce Department can vary from one case to the next fairly significantly, depending upon how the case is handled and how it's argued by the counsel. So, all right, let's move to the next slide. Again, in the interest of time, I think let's move forward. This is just more detail on the standards for circumvention. So scope inquiries, go on to the next slide, Aaron, thank you. Scope inquiries are tricky, and a lot of the, just so you all know, when we define scope in an anti-dumping or countervailing duty case, they can be very, very complicated scopes. They don't just follow how the product is defined in the harmonized tariff schedule. Okay, so for instance, you could have a product that is more narrow than the harmonized tariff schedule item for a particular product. Or you could have it, there are scopes that have multiple HTS items. There are scopes like the one I mentioned already that's pending right now on aluminum extrusions that are that include not just the product, not just aluminum extrusions, but aluminum extrusions included in downstream products. Very, very tricky stuff and difficult to know how Commerce is going to rule. And so what oftentimes happens is companies will say, okay, well, I don't think my product is subject to this case, so I'm not going to pay anti-dumping and countervailing duties on it. And then lo and behold, someone comes along and challenges that. Could be the domestic producers, it could be an importer. It could be customs who refers it back to Commerce and says, hey, we're not sure how this should go, so Commerce, you figure it out. And if Commerce determines that it's always been within the scope, they can literally require the importer to pay duties on this product going all the way back to the beginning of the order, or if the order's been in place for, you know, decades, they'll go back to the date of their new regulations that they issued on scope and circumvention back in late 2021. So again, another example of potential retroactive liability that needs to be watched carefully. So if you have a question about scope, whether or not your product is in, it's a really good idea to seek counsel to figure out if it's in or out, so you can avoid this kind of catastrophe that might happen later where you're subject to duties going back quite a ways. Okay, let's go to the next slide. Okay, Aaron, go on. There are a variety, and there are a variety of new regulatory efforts to expand the Commerce Department's authority in this space. There are proposals that are pending. There's been a proposed regulation that Commerce is still working on, addressing the three of these issues that I have here. The one that may be of most concern to people, because it kind of makes some sense, is what are referred to as transnational subsidies, where a case is brought against Vietnam, for instance, but the company that's producing in Vietnam and selling to the United States is a Chinese company, and they've benefited from subsidies that are provided by the Chinese government. And how do you address that in a case against Vietnam, where the Vietnamese government hasn't provided any subsidies at all? Well, this change in law is aimed at possibly addressing the Chinese subsidization, the benefits that the companies have received even from a different foreign government. Some other examples that, not to go through each and every one of them here, but Congress is also considering some changes. There's nothing pending right now, but for a long time there's been talk about addressing currency manipulation or undervaluation in China and other countries, and addressing those issues through the countervailing duty laws, treating that as essentially a countervailable subsidy. There's talk about not allowing foreigners to be the non-resident importers of record, which has been a method through which companies are trying to take away, exporters are taking the risk away from U.S. companies by taking on that risk themselves. So there's a lot that could be going on in the future here that should be watched carefully because they're just trying to increase the risks on bringing product into the United States if subject to these kinds of laws. Okay, let's jump ahead because we're running low on time. I'm gonna jump through this, and Brooke, let's get started on the other types of trade remedies. Brooke and I will both talk about these a little bit. Go ahead, Aaron, to the next slide. So this is just an overview slide. In addition to anti-dumping and countervailing duties, there are now multiple other provisions of U.S. law that are being used to increase duties on products coming into the United States. Section 201 safeguards, Section 301 tariffs, which you know about, probably have heard that number because of our trade war with China. This is as a result of Trump's duties imposed back starting in 2018. Section 232 tariffs, which were also not common until Trump came along, and those are imposed against and still in place against imports of steel and aluminum. And then Section 337, which has been around for a long time, but is an area that's they're actually pretty common, but it's a sleeper area that some folks may not be as aware of. So let's move on to the next slide. Section 201 safeguards are really unique in the sense that they allow, they're sometimes referred to as an escape clause, because petitioning industries who bring these kinds of cases don't have to prove that there is any kind of unfair trade activity like dumping or subsidization. They just have to prove that there's been an increase in imports and it has caused serious injury to their industry, and as a result of that, they're basically asking the U.S. government for help. They're asking for an escape from normal competitive dynamics. So these have been used pretty rarely up until 2017. The last time we'd had a safeguard case was the steel cases, which were controversial themselves. But then in 2017, new cases were brought by Whirlpool against large residential washers, and importantly, these kinds of cases, they're called global safeguards because they're against all imports, not just specific countries. And then the other big one that's still in place today is the one on solar cells and modules. The solar cells and modules safeguard ultimately was extended and will, by the end of its run, will have been in place for 8 years. And so important to watch this. These duties are final when at the time of entry, unlike anti-dumping and countervailing duties. They can't be any greater than 50%. They do have to get smaller, progressively liberalized over the years that they're in place. So it's and ultimately it's up to the president whether to say yes or no on whether or not to even impose these duties. So it is again something to watch, but it's not very common. But in the cases that have been brought in the last few cases that have been brought, they've been worth billions and billions of dollars in trade. Even the case that we ended up winning on blueberries was worth billions of dollars, but that did go negative at the ITC. Okay, let's go to the next one. This is really the one that's probably that folks have read the most about. Section 301 is the provision that the Trump administration used to impose duties of on billions of dollars, hundreds of billions of dollars of product from China. And during the Trump administration, there were lots of threats of using that law against a variety of other products as well. In the past, it's been used against beef from concerns about what's happening in the European Union with regard to aircraft and beef, concerns in Vietnam about currency manipulation, illegal timber harvesting. The breadth of this law and the way it can be used against digital services, taxes in a variety of countries, it is very broad. And how often it will be used, not clear, but it is a worrisome area, a worrisome law to be used. Potentially, if there's a Trump administration next year, you could see this law being triggered more in the future. Let's go to the next slide. This just gives a little bit more detail on what's happening right now with the 301 case against China, the duties against China. We're involved in leading a lawsuit against these duties for list 3 and list 4. And that's still pending before the courts. There's also a necessity review going on right now, which is kind of like the sunset review I mentioned earlier, whether or not that these duties should remain in place past the first 4 years. The necessity review has already taken much longer than a year to conduct, and unfortunately there's no deadline in the statute indicating when that review should be done, and so that's why I think the Biden administration is kind of taking advantage of that reality. Okay, let's move on to section 232. And if I've missed something at all, Brooke, you'll speak up, I hope.
Okay.
On 232 is a provision that gives pretty expansive authority to the president, and most of the litigation in court over the use of this law has run its course, and for the most part, the courts have decided that the president's authority with regard to national security and how national security is defined in that law is very, very broad. And one of the things I've always been concerned about how this law could be used in the future and how other countries could potentially try to use similar theories is that any kind of product that's important to the national economy could be deemed to be a national security concern if enough imports are coming in and challenging those products. So the point is this law, it's there, it's being used in the tariffs against imports from most countries on steel and aluminum. There are several countries. Let's go to the next slide. There are several countries that are exempted and are subject to quotas or tariff rate quotas instead. But the concern here is that this law could be used even more broadly going forward. And this is another area, and the use of national security justification is another area where we're seeing challenges at the WTO, and the question about whether or not Article 21 of the GATT provides, is really an exception that is as broad as the United States claims that it is. And Brooke is a co-author of an article on this topic that is worth a read, because this is something that's actually, in fact, going to come up, presumably is coming up during the course of discussions at the WTO, at the ministerial that's happening in a couple weeks, and whether or not there's going to be a change in how the WTO approaches this question of national security. Is it as broad as the United States thinks it is? Are countries able to trigger it just at their whim, or must they abide by a more specific definition of national security? Okay, let's go on to the next slide. 337 is just another area of law that we have here in the United States. It is a fairly commonly used area of law to address violations of intellectual property primarily, and mostly patents. When product comes in the United States, this is a potent law that allows a company or an industry in the United States to exclude product coming into the United States. So not just duties, but an actual exclusion, a ban on those imports if they're violating an intellectual property right. So with that, and that's a good segue, I think. Let's move on to the next slide. It's a good segue to what Brooke's going to talk about, because in the same way that Section 337 allows a company to exclude a competitor's product at the border, as opposed to just imposing a duty at the border, which most of our other laws do, forced labor does the same thing, allows for the possible exclusion of a product, detention of a product. So Brooke, why don't you take it away?
Great. Well, thank you, Matt, and thank you to Mondac for having us. Like Matt said, I'm going to be walking you through the major forced labor statutes. The principal forced labor statute in the US is Section 307 of the Tariff Act of 1930. And that act prohibits the importation of any good, wholly or in part, made with forced labor. However, the Tariff Act is also supplemented with certain geography-specific legislation. And I'm going to talk for the most part about the UFLPA, but I also wanted to give a quick mention to CATSA, which is the Countering America's Adversaries Through Sanctions Act, which establishes a rebuttable presumption that any good made with North Korean labor is necessarily forced labor, and as such, under Section 307, is prohibited from entry into the United States. And I think CATSA mostly has been applied against Chinese companies and Chinese suppliers, at least for the moment. And on to the next slide, please. So I'm going to spend the majority of my time, and I'm going to try to leave some time for Q&A, talking about the UFLPA, which is the Uyghur Forced Labor Prevention Act. Congress passed the UFLPA after rising concerns over the humanitarian situation in the Xinjiang Uyghur Autonomous Region and allegations of widespread use of forced labor among the Uyghur minority. And the UFLPA's stated objective is to stop the importation of any goods mined, produced, or manufactured wholly or in part in the XUAR. And to do so, the UFLPA establishes a rebuttable presumption that goods are made with forced labor and thus prohibited from entry into the United States if they were, 1, mined, produced, or manufactured in whole or in part in the XUAR, or if they were mined, produced, or manufactured in whole or in part by an entity on the UFLPA entity list. And that list is maintained by the Interagency Forced Labor Enforcement Task Force, or FLETF, and I'm going to be talking about that a little bit later and go into a little bit more depth on FLETF. But a little bit more on the rebuttable presumption. So that presumption remains in place even if there was a substantial transformation of the goods in any other region or country. And it also remains in place no matter the percentage of the good that may originate from the XUAR. So in other words, there's no de minimis exception to the rebuttable presumption. Next slide. And thinking about kind of the high risk areas for enforcement under the UFLPA, CBP takes a risk-based approach to its targeting of goods and sectors that it believes may originate from the XUAR. Originally, it named apparel, cotton, silica-based products, tomatoes, and certain downstream products as high priority for enforcement under the UFLPA. But in 2022 and in subsequent times, CBP has expanded that list to include aluminum and polyvinyl chloride products, among others. And these priority sectors continue to be updated, and CBP's targeting strategy has continued to evolve. And we know, in thinking about kind of where CBP might target next, we know that CBP often relies on NGO and media reporting, as well as kind of directions from congressional leaders to shape its targeting strategies. And as that reporting moves on to new sectors, CBP may adjust its targeting strategy in turn. And so we therefore suggest that importers track news reports of activity in the XUAR in their sector, track NGO reports, in order to better understand their potential exposure to UFLPA enforcement in the future. CBP has also taken a risk-based approach to the targeting of entities. Of course, entities on the UFLPA entity list are at high risk of an enforcement action, as well as entities affiliated with those listed entities. So subsidiaries, parent companies, sister companies are also exposed by the very nature of their affiliated entity being on that list. And then, of course, importers that source from entities on the entity list and have them in their supply chain are at higher risk of having their shipments detained as well. And finally, I note briefly here too that CBP has not solely targeted shipments coming from China, but from third countries as well, and particularly Vietnam and Indonesia. Next slide. Now, as I noted before, the FLETF is charged with maintaining the list of entities on the entity list, and it has periodically released updates to the list since it was first published in 2022. And to add an entity to the entity list is actually a pretty low bar. Only one FLETF member agency needs to submit a recommendation, and then the FLETF will pass that recommendation with a majority vote. And FLETF member agencies are not held to a burden of proof. They can recommend the addition on a mere suspicion alone. And so for this reason, entities that have been linked to the XUAR in media or NGO reports are at a higher risk of an entity listing and should be aware that a listing is a possibility. Moreover, the process for removal from the list is quite cumbersome. Listed entities have to submit a removal request demonstrating that either they never did or no longer meet the criteria for which they were listed. But we're not aware of any successful removals to date, and it appears that making a successful request is extremely difficult. Next slide. So if an importer receives a UFLPA detention, that importer has three main options. Probably the most viable response is to request an applicability review, by which the importer has to demonstrate with clear and convincing evidence that the detained good shares no nexus to the XUAR and thus falls outside of the scope of the UFLPA. This is a very high bar to meet, and it requires importers to furnish an extensive amount of supply chain documentation proving the shipment's lack of connection to the XUAR, and they have to do so in a relatively short response window of 30 days. There have been goods, though, released through this route, including in the cotton, apparel, solar, and other sectors. And so this is a viable option for importers who are prepared to submit an applicability review request. Second, importers can attempt to rebut the presumption and argue that even if the goods do have a connection to the XUAR, that no forced labor was used during their mining, manufacturing, or production. But I'd emphasize here that actually no importer that we are currently aware of has successfully met this bar. And so even though you technically can attempt to rebut the presumption, it's extremely unlikely for that to be successful. And finally, as a third option, importers can request to re-export the detained shipment. And while this may get your shipment immediately released, this also can increase the risk of future detentions, as CBP may believe that the importer was unable to furnish the supply chain documentation necessary. And go on to the next slide. So, if an importer receives a UFLPA detention and wishes to either request an applicability review or rebut the presumption, both responses will require the importer to furnish a very detailed set of supply chain documents, showing that either the goods have no connection to the XUAR or that any activities in the XUAR were not conducted with forced labor. And that documentation can only touch on the importer's tier 1 and tier 2 suppliers, but all upstream inputs reaching back to the raw materials. So if CBP detains a shipment of cotton t-shirts under the UFLPA, it will expect to see supply chain documentation showing the origin and chain of custody of the exact raw cotton that was harvested for that exact shipment of t-shirts, along with any other input. And gathering this level of detailed documentation is a very time and resource consuming effort. And so for this reason, when working with importers, we suggest that they put a system into place proactively to ensure that they can access those documents before receiving UFLPA detention. We suggest, for example, that importers run a mock detention where they request documentation from their suppliers for a certain shipment to see which types of documentation they could gather under a UFLPA detention. And then they can work with their suppliers to close any gaps in that documentation ahead of any potential detention in the future so that they're ready to respond in that window. We also suggest that importers take other actions, such as disseminate and enforce their forced labor policies, incorporate contractual language obligating suppliers to comply with their policies banning the use of forced labor, and make sure that they're regularly training their own teams and their suppliers on their forced labor policies. So while you as an importer may not be able to necessarily stop a UFLPA detention from ever occurring, you can take a number of proactive steps to ensure that if you receive a UFLPA detention, you can provide as strong of a response as possible. Next slide, please. Matt, I'm going to hand it back to you.
Okay. And we can run to the Q&A quickly. These last couple of slides are really kind of pulling back again and looking at the broader issues about how companies can prepare for and what they should be looking for. This is mostly with regard to new anti-dumping and countervailing duty cases, but the fact is that increasing imports at lower and lower prices is sort of your hallmark for when new cases are being brought, and that applies frankly to the same kinds of concerns under Section 201, even other areas of law, including Section 232. If you look at what happened with steel and aluminum, that's exactly what was happening. So anyway, I think we could probably, with just 8 minutes left, we could address questions that anybody has. Aaron, actually let's go to the next slide. Sorry, I jumped over. Yeah, I think this is basically just making similar points here. So I think we have at least two questions that we could spend some time answering, right?
Sure.
Jenna, do you want to take over?
Yes, absolutely, Matthew. I've got and Brooke, I've got a couple of questions for you submitted. So the first one being, if CBP asks a small business for information about their raw materials, does the small business have the same requirements as a large business?
Yeah, I'm happy to take that one. Yeah, unfortunately, if you're a small business, a large business, the CBP's requirements are the same. They're going to expect that you can furnish the same types of supply chain documentation as any other importer. We know that this can be extremely burdensome on small businesses who, have smaller teams and leaner resources and may not be able to spend the time and money necessary to respond in such a short window. And this is why we really emphasize for all companies, but especially for small businesses, to really take the steps that you can beforehand to proactively prepare for a potential UFLPA detention. Because when that detention comes, you have 30 days with the possibility of a limited extension to gather an enormous amount of documentation. The UFLPA applicability reviews that we have worked on, the packages are, number into the hundreds to even thousands of documents. And for a small business, that can be a nearly impossible task to complete within such a small window. And so, once again, taking those proactive steps, running a mock detention can save you a lot of time and money in the future if that detention does happen to come down the road.
Brooke, let me make a broader point as well in answer to that question, because I think, and this unfortunately applies to large and small companies alike, I think during the COVID years where COVID was raging and people were not traveling as much, and now that we all rely on things like what we're using today, these video platforms, I think people are not traveling as much as they may have before, and they're not as aware of what is happening on the other side of the planet with some of their supply chains. It's really critical that if you're not able to travel yourselves, you need to have trusted people on the ground in other parts of the world where you're relying on, whose supply chains you're relying upon, to go and check it out for you. Ideally, your people yourselves should be checking it out just to make sure that whether it's forced labor concerns or making sure that product is not being, fraudulently relabeled and, suggesting that it's no longer a Chinese product when in fact it is a Chinese product. Lots of ways in which foreign companies are being careless or in some cases fraudulent about their supply chains, that ultimately hits the importer of record here in the United States, and can come back to bite others as well. So it's an area, this concept of due diligence, right? Doing your due diligence to make sure that you're aware of what's happening, where your products are coming from, not just your products, but where the inputs to those products are coming from, which is what is so critical for forced labor. And I don't think you mentioned it earlier, Brooke, but this is something that's really important, I think, for people to recognize, is that under UFLPA, most of the detentions that have happened are on product that have come from other countries, not directly from China, right? So, for instance, I think Vietnam or one of the other countries in Southeast Asia,
Vietnam and Indonesia, yeah,
Vietnam and Indonesia are the largest targets of UFLPA enforcement, because there has been an allegation made that a lot of the inputs that are going to those products that are being further manufactured in those countries are coming from China, and specifically from the ex-UAR. So really important that you get boots on the ground to see what's happening with your supply chains for all sorts of different reasons.
Thank you, Matthew. Thank you, Brooke. We do have a couple of other questions. We've got a couple more minutes left, so hopefully we can fit these in. Mike has asked, how is the normal value calculated in USD when the home market is denominated in a different currency?
Yeah, I mean, that happens as a matter of course. It always, in fact, almost always is the case that the home market prices and costs are denominated in a different currency. But there's a methodology that Commerce uses to adjust exchange rates, so that you're comparing apples to apples. There's a whole series of adjustments that are made, calculations that are made, so that you have an apples to apples comparison, both with regard to ensuring that you're comparing the same product, that you're comparing same product to the same essentially level of trade. They're trying to make sure that you're comparing at a ex-factory US packed price, basically. So they're taking out transportation costs, et cetera, and they're making these other adjustments, like with regard to exchange rates, to ensure that they're comparing a US price to a US price that's adjusted in accordance with whatever exchange rate they're using. Those rules and how they go about that are complicated, but they're part of the Commerce Department's standard calculation program that they use for calculating the dumping margins.
Brilliant, thank you, Matthew. I'm not sure that we have time now, as we have come towards the end of the webinar. Robin has asked, how does Canada's new forced labour law compare with the UFLPA? You can take this offline and answer, Robin, or you can answer now if you can squeeze it in.
Happy to try to squeeze it in. So thank you for that question. So the Canadian forced labor law, it's much more based on reporting than on enforcement. So that's kind of the key difference that I think I have time to pull out now. I will, though, highlight that, if you're looking abroad to other jurisdictions, it's important to look at some of these emerging countries that are coming out with new forced labor regulations, like Mexico, for instance, which does have certain mechanisms for enforcement that are stricter than the Canadian regulation. You have Germany coming out with new forced labor laws that have both a reporting and an enforcement mechanism. So yeah, just to give a brief overview at the time we have left, those are the main differences.
And Jenna, I would just end with just a plug here. The fact is that so much of what we've talked about today, and as you can tell, we're sort of rushing through to cover all of this material in a single hour. There's so many more details that we could get into in a longer webinar, but obviously much of the questions that people end up having are having to do specifically with their businesses. And so obviously, if any of the attendees have any further questions and want to reach out to us, that's what we're here for. So.
Brilliant. Well, thank you, Matthew. Thank you, Brooke, for hosting today. And thank you very much to the audience for joining.
Great. Thank you, Jenna. Thanks, Aaron. Thanks, Brooke.
Thank you, everyone.